I want to welcome everyone to this event. Glad you're all here. This event is presented by Project Sentinel in the CRLA here in Stanislaus County. My name is Mark Galvin. I'm the landlord tenant case manager with Stanislaus County, and I work for Project Sentinel. But today we're going to have a presentation from Aurora from CRLA, and also from Emily, who works for Project Sentinel, and also Starlene Kilgore will be on board for homeowners services that we have within our corporation. First off, you should know that we're recording tonight's event, and that means two things. If you have people who want to see this and couldn't attend, they'll have a chance to see it at a later time, as well as if you send in your questions, we'll hold them all. And if we can't get to them on tonight's event, we will get back to you via the phone and answer your question directly. Okay. Also be aware, we'd like to know, we have both landlords and tenants in here. We'll have a survey pop up very soon. If you leave, please could fill that out, and that would help us out. And also at the end, we'll be doing a short survey to get a kind of snapshot on time of what we're doing and how we can do it better for you. And we really appreciate your time tonight. So we'll not waste any more time. We'll cut it to Aurora.
Great, thanks, Mark. So Emily, if you want to go to the next slide, I think that's, well, there's an intro for Project Sentinel first, right? So I don't know if you want to take that, Emily.
Mark, do you want to briefly tell them who we are or what you do? Oh, you're muted, so.
Sorry. I'm sorry. I'm in Stanislaus County. I'm the landlord tenant case manager for Stanislaus County. I don't advocate for tenants. I don't advocate for landlords. I advocate for following the civil code. I've been here 10 years with Project Sentinel and then been involved in the courthouse, lawful detainers, and in the mediation center. I try and resolve your issues and keep you out of court if possible. We have several services that we do throughout the Bay Area. But basically, that's what we do here. And tonight, you'll hear from Emily, who does rent stabilization programs, and Charlene, who does the housing mortgage counseling for the company. We're a free service. We're located here for mediation. We're also in the small claims court advisor, and we also have mediators in the UD court. So that's basically us. Next slide.
Great. And then my name is Aurora Thome. I'm the directing attorney at the California Rural Legal Assistance Office in Modesto. And we have a little bit of history about CRLA here, founded in 1966, and we provide free legal services to low-income people. In the areas we specialize in are housing, education, employment, and public benefits. So there's the contact number for the Modesto office. We did recently move, although we are also all mostly by phone now. So that's our contact number is the best way to reach us. All right, great. So the entire presentation, the goals are to cover an overview of COVID-19 emergency eviction protections and what tenants need to do. And I'll be covering that. Emily will be covering what landlords need to do and the rent relief programs. And then Charlene will be covering the small landlord mortgage relief options. Go to the next slide. Okay, so we're going to get right into the temporary COVID-19 eviction protections. And I just want to call attention to the title of this slide. These are temporary eviction protections. It's not an eviction moratorium. And I think sometimes people hear the term moratorium in the press, and there's definitely people who think that no one can be evicted right now. And that's not true. There's not a complete ban on evictions. What there is are temporary protections for all residential tenants in California. And that includes mobile home tenants. It includes everyone, regardless of their immigration status, regardless of whether they have a written lease. These protections are going to apply. And what the protections mean is that tenants who aren't able to pay their full rent because of COVID-19, so because they had some loss of income related to COVID, whether they lost a job or they got sick, can never be evicted based on that unpaid rent for any unpaid rent between March 1st, 2020, and now it's been extended through June 30th, 2021. And there's a big asterisk next to that, which is they can't be evicted as long as the tenants comply with a few things that they need to do to let the landlord and the courts know that the reason they can't pay their rent is because of COVID. So Emily's actually going to talk a little more about the forms that landlords need to provide to their tenants, and then that tenants need to give back to their landlords to say, the reason I can't pay my rent is because of COVID. So that's the major thing that tenants will need to do. If they get a notice from their landlord that they owe rent, they're going to have to use that COVID-19 declaration to say, to let their landlord know that the reason they couldn't pay that rent was because of COVID, and that will protect them from being evicted for that unpaid rent. Another important note is the unpaid rent is not being forgiven, although there are repayment options from the state that, again, Emily's going to talk about later. Actually, sorry, not quite done yet with that slide. If you want to go back, the rent it's not being forgiven, but it is, but it can't be used to remove someone from their home. So I'm going to talk a little bit more about what that means later. So basically these protections apply, and through June 30th, 2021, evictions are only allowed under limited circumstances, and any termination notice has to state a legally valid reason. So in some cases, landlords can just evict someone because they don't want that person to be a tenant anymore without giving a reason. But this law requires for all tenants that landlords provide what's called a good cause reason for if they want to evict a tenant. All right, now we can go to the next slide. Thanks. So some more important notes. So tenants with unpaid rent have to take certain actions to be protected. And that's mainly going to be filling out the declaration that Emily will show you later and returning it to their landlord. It's really best for everybody if this gets done before a landlord files an eviction in court, because tenants do have the opportunity to turn in that declaration to the court after an eviction is filed. But that means that the landlord has already spent money to file the eviction. And it can be, it's a lot more, it's a lot more hassle and a lot more cost for everyone if it actually ends up in court. So what this law does is try to provide a way for tenants to take action to prevent an eviction case from going to court. Landlords are also supposed to give certain documents to comply with the law and allow tenants to preserve their rights. So Emily will show you those later. And tenants do still owe the unpaid rent. So the way that courts are doing this, or the way that the law structures this, is that landlords can file collection actions in small claims court, but only after August 1st, 2021. And what a collection action means is they'll be able to get an order from the court saying that the tenant owes them rent. But again, they won't be able to use that to remove the tenant from their home. And then also what this does is give time for both landlords and tenants to take advantage of the rent relief programs that the state is just kicking into gear. So landlords who eventually refuse, if the tenant is eligible for those rent relief funds, the landlords won't be able to recover the amount of rent that the tenant owes from the tenant. So there's a big incentive for landlords to accept these relief funds from the state. If you can go to the next slide. So there's other protections in the law. One is that their landlords can't charge late fees for this rental debt that people have because of COVID during this period from March 2020 to June 2021. That rental debt can't be used as a negative factor in screening tenants down the line. That debt can't be sold or assigned if the tenant will qualify for this rent relief program. And then if the tenant does not qualify for the rent relief program, the landlord can sell it to collections after July 2021. So again, the law is trying to incentivize not turning this rent over to collections So right now it cannot be turned over to collections at all for anyone until July 1st. And even after that, if the tenant would have qualified for rent relief, the debt should not be sold to collections. And then going forward, landlords will have to apply rent payments to the current month's rent. So they won't be able to go back and say, okay, I'm going to use this to cover unpaid rent from during the pandemic. It will have to be applied for the months that the tenant is for the current month. And they can't use the security deposit to go back and pay for that either. And then retaliation against tenants with COVID rental debt is barred and could subject the landlord to fines and penalties. Next slide, please. So some advice for what tenants should do. So tenants will have to pay at least 25% of their rent that was due each month, or any months that they didn't pay the full rent. They will have to pay that by June 30th, unless they're able to get other relief from this rent relief program. So like I said, Emily's going to talk a little more about that, but the rent relief program might be able to help them either pay that 25% or completely pay off, basically pay off their rental debt. And so tenants won't have to pay that 25% anymore. So although the advice is to try to pay at least 25% of your rent each month, I think there will be more information about these rental relief programs coming soon. And tenants and landlords should be aware that there most likely will be relief available from the state to pay off any of the debt that has accrued, as long as the tenant qualifies. If the tenant can't pay because of some COVID-related reason, they should sign and return that declaration and keep doing that every month as long as they continue to be financially impacted. And then we always advise everyone to carefully review any documents they're given, and they can call us or Project Sentinel or the Stanislaus County Mediation Center if they have questions. We encourage everyone to keep notes of how much rent they've paid and to call us if they have questions about their rights or responsibilities. And I think that is the end of our tenant section.
Myself there.
I want to try to stop for potential questions there.
Yeah, Mark, do you want to see? I think there was some activity in the chat. We would like people to try to use the Q&A function. But Mark, do you have anything so far that we won't be?
Actually, there were a couple in the survey. Somebody will be able to use throughout. Can they use these forms at the housing is key? Other locations other than Stanislaus County? Yes, they can. They can be used statewide.
Mm-hmm.
And then somebody want to know if we're recording this. We are, and we'll be recording out this later. Not many questions other than that. So hopefully everybody wakes up. We have about 53 participants at this point.
Okay. Yeah, and I'll just mention just before we go on, and this might be touched on later, but there are also some federal protections. So everything that I said here applies to the whole state of California. This is a California law passed by the California legislature. There was also an order by the CDC, which is about evictions for non-payment of rent. But for most people, that's going to provide less protection than the California law, except in a few rare circumstances. So even if someone, what I will just say about that is even if someone can't pay because of a reason other than COVID. So for example, we've had people where a family member passes away, so their income goes down. There still might be protections from the CDC order, and we definitely still encourage people to call and see what their options are.
We do have a slide, but I figured that would confuse people. Okay.
We might have a question coming in.
Is there any questions on this tenant portion, Mark, you think?
Yeah, we have a couple. You guys can answer live. One is, what stats do we have on how many renters there are in Modesto or Stanislaus County? And the other would be, somebody's asking, should tenants that are aware of these rules get a declaration and give it to their landlord, even though the landlord has not provided them with any or all the information?
Mhm. Okay, so I'm sorry. I'm going to answer the second question
That's fine.
first. I think that's going to be something that's sort of up to the individual tenant. I'm not sure there's a there's a definitive legal answer to what's the best. Should you provide this declaration to your landlord, even if they haven't given you a notice, for example, saying you owe the rent. I think it could help let the landlord know, okay, this is why I'm not paying. It's because of COVID, and make sure that they receive it. But there's also, tenants might know their landlord best. If their landlord, if they don't want to, if things are going smoothly right now, they might not want to give them that notice to that could kind of trigger something to change. So I think that's going to be up to the individual people. And then what was the
number of
other question?
Do we have any stats about how many renters or how many in Modesto or Stanislaus County?
How many renters there are total?
That's what the question is.
I don't have that off the top of my head. No. I don't know if anyone else has any. Yeah.
census data if you Google like US Census information, I don't know if it will have 2020s, but I think that's some information the government collects.
Okay. Yeah. And then so I see Rosalind asked in the chat, if a tenant's sole income is from benefits that haven't been impacted by COVID, can the tenant still qualify for relief? Is the documentation complicated, or have considerable documentation for proof of impact? And yeah, I did just talk about that a little bit with the CDC order that would protect people if they're even if they weren't able to pay for some reason other than COVID. And there might even, even if their income comes from COVID, if you take a look at the declaration, it really is pretty broad. If you had extra expenses because of COVID or something like that changed, because of lockdown or something like that still could be considered because of COVID. The courts are not supposed to ask for any proof of that, but the person does have to sign the declaration under penalty of perjury. So we just people should only sign the declaration if it's true in their case, but it doesn't have to be just because they lost a job because of COVID or they were sick. There can be much broader circumstances that made it harder for them financially, that came about because of COVID or because of the public policies that have gone into place since the pandemic.
We also have one more requesting. I see that Christine's an answer, but it says what resources are available to renters who are Spanish speaking. I know here at Project Center you can call us, and we do have a Spanish speaking person and staff that can answer those questions. And I'm assuming CRLA has the same skill set. Well, both agencies, call us up. We'll help you.
Yes. And actually I can put in, if you call our office, you can get screened to be a client, or they'll also let you know we have a housing workshop that we're holding outdoors at Griseda Park at 1 p.m. every Thursday, and people can get information there, and that is in English and Spanish. And the COVID declarations were available on the Department of Real Estate website. I'm skipping ahead a little. In I think 5 different languages, and now for some reason when I just looked it was only in English, so I don't know if they're updating things. Last week it was there, so those should be available in English, Spanish, Chinese, a bunch of different languages. And then I see someone just asked about flyers for the Thursday workshops. Yes, we do have those. I can either figure out how to post something in the chat, or I can give it to Emily and send out with the recording of this.
Yeah, and I think we can maybe drop it into the Q&A if someone asks for a flyer. I think we can. I think we can send the chat to the attendee. I will just add, they are, so all the forms that we're talking about on the housingiskey.com website of the states, you can even use the translate function at top and then get to the forms. They're in multiple languages. I just assume that they're translating right now, the declaration form. And as I will say, with the landlords, you need to give some of these notices and forms in the language that you negotiated the contract in. So,
Right. Yes.
and, you know, it's always good practice if you know that your tenant is, their primary language is not English, to provide them copies in both.
Yes. Yes. So fair housing protections are still going to apply, and language and rules about language access. My boss Jessica is also on and points out that we also have strong language justice practices. We can also provide services to clients in other languages, and you know, through interpreters. But we do have people who will be there in person in English and Spanish for sure. And then we'll get interpreters for other ones, or get another CRLA staff member. I did just see someone ask about the panel about the having to apply the rent to the current month. Yes, that is a new provision of the law. So I can look up that exact site for you, Janae, and put it in the chat. I don't have it handy unless Emily's going to right now. But yes, that is specifically spelled out in the protections. And that's one of the new things that came out. This law just got updated at the beginning of February, and that's one of the newer provisions. So there have been some changes and extensions, and everyone is catching up to them.
And maybe Mark or Christina, if you could do a quick poll of who we like, so we know we're spending equal time on, you know, tenants or landlords. One of you say yes if you, I'm typing in a code section right now.
I'm going to default to Christina about doing a poll.
Okay.
Here comes the poll, everybody.
So just let us know, you know, what your role is here. It should be seen.
Oh, there it is. Perfect. We do have one question about from David. Can a landlord retaliate towards a tenant if the landlord is reported? The answer would be no. But I'm assuming this is outside of the COVID protections, what you're requesting.
I
that
do have a
information.
slide later about what types of things that can constitute retaliation.
Okay, great, Emily. Thank you.
I don't know what they mean reported.
I know.
So we've had, let's see, how many people? There are lots of other. Okay,
Others, what are they doing?
we'll let it go. So 38 of 48. Any more tenants, landlords, or property managers? There are lots of other who want to know everything. Okay, I think we could end the polling.
Aurora, they're looking for a flyer on your Thursday group meetings you have out of the park.
So maybe
I
I'll
will-
look into the, if you have it, Aurora, you can do chat and do all panelists and attendees. I think you can send a link or even a file through there. So if it's okay with everyone, I will, do they have to submit? I'm just going to quickly answer one question that I see because it pertains to landlords too. If this question is, if a tenant is Spanish speaking and the original lease is in English, do they have to submit an English declaration? What can happen if they send their landlord the declaration in Spanish? So first of all, the landlords are the ones required to give the tenant a blank declaration. What you can do if you want to make sure they have it, you can give, there's Spanish and English declarations available. But if it's on the state form, I would imagine that the landlord would have to accept that if the tenant has signed it. but it should look the same. I'll show a picture of what this form looks like. So if a tenant doesn't read English but sees a form that looks like that, that's probably their declaration. But Aurora could maybe speak to whether, that they're Spanish speaking and the lease is in English, what the requirements are for language.
Oops, I lost my unmute button for a second. The question was, do the landlords have to provide the form in language if the lease is in English?
But they know that.
So the landlord should provide forms in the language that they use to communicate, or that they negotiated the lease in. So they should also provide the lease in the language they negotiated the lease in. I would say best practices, if you know your clients, if you know your tenants speak a language other than English, to provide them the form in that language. I don't know that there's this, it's always best, like I said, I think it's in everybody's best interest to have everybody understand these declarations and try to get them in before a case is filed in court, so that nobody wastes time or resources. So, and I don't, I can't say for one way or the other if it's going to come up later on that, oh, you should have given the tenant a form in a different language. That could be an issue that gets brought up. So I think we just want tenants to be aware that even if they don't get it in their language, they can go and find it. And for landlords, it's probably best to give it in the language the tenant speaks, or give multiple ones.
Yep.
We're also being asked if there's any consequences to a landlord if they don't give the forms to their tenants.
So I'm gonna, Mark, I think that might be a good segue for my part.
Okay.
I'll
All right.
cover that. And also the declaration is one page, so you could double side it, English, Spanish, if you want, then you're not wasting paper. Okay. It's not responding. So speaking of notices and declarations, there is something landlords are supposed to do under the law by February 28th. And they are supposed to serve this particular 2-page form that's on the state's website that's notifying the tenants of their rights and responsibilities, pretty much everything we're covering in this webinar. So this is what it looks like if tenants receive this. So landlords are supposed to serve this on any tenants who have unpaid rent since March 1st of last year. If you've done another notice in the past, it can't hurt. You need to let them know that the law has been extended to June 30th. And so tenants, if you receive this notice, you're just being notified of your rights. You're not in trouble. They're just acknowledging that you have unpaid rent and this is what you need to do. So that's something landlords are supposed to do by the end of this month. And I know I'm going to have questions about what if I don't do it by the end of this month. Just do it. It's when you know and you can do it. Because going to the question that was asked about what the consequences are is if you have not complied with certain laws, that's going to preclude you or bar you from trying to seek remedies at some point. It's a short time frame. I would just say as soon as you're aware of this form and have access to it, to serve it. But if your landlord serves you 2 weeks after February 28th, it's hard to say whether a judge would think they didn't comply. The whole point is to notify tenants of their rights. Landlords, if you are going to serve a notice to pay or quit, it must be a 15-day notice and must contain specific information about the protections at law. There is a form on the website. I would recommend using the state's form because it has the language that needs to be there. And that form has a place for you to list out each month of rent where the rent was not fully paid, or if it was, and what was paid. So it's like an accounting. Now, if you are serving that, you also must serve a blank declaration of COVID-19 related financial distress to the tenant, preferably in the language that the contract was negotiated in. This is the form. It's on the state's website. You should use this one because it has all the information that is supposed to be provided. There are links to where tenants can find help. And for tenants, You're basically, by signing this form, you are telling that you are swearing under penalty of perjury that you have been financially impacted and are unable to pay full rent because of, could be one of these reasons. There's examples, staying at home because you need to take care of kids who are remote learning, you had reduced hours, you've lost your job. There's a lot of ways people are impacted. So they've tried to cover most of those here. If you are not falling into these categories, that's where it would be a good idea to contact CRLA to see if the CDC protections might then apply to you. But I think most people would fall under this one. Now, landlords should be telling tenants how to return the declaration to them, should give them instructions. And tenants, you either give it to them in person, you give it to them in the manner that you normally pay rent or provide other notices. I recommend that people take a picture of it after they've signed it, because you store that picture in your phone and it's like having a copy, or make a copy. But landlords are supposed to serve this like they would serve any other notice, either in person or by mail and stuck to the door. So it is quite possible that a tenant could receive the notice that we saw on the first page, a 15-day notice to pay or quit. Even all that means is that they have to return that declaration within 15 business days, and a blank declaration form. So they might be receiving 3 documents. Don't panic. This is what the landlord should be. They are fulfilling what their obligations are. So landlords, if you do not serve this declaration, that's one of the requirements to file an unlawful detainer at any point. So that's what they must do to comply to reserve their rights. Just touching upon, so there's some stricter penalties for retaliation in SB 91, the extension of the statewide eviction protections. Just to sort of go over what those are. So this is, if you take any of these actions and it might be seen as in response to somebody who has COVID-19 rental debt. So it's illegal for a landlord to discriminate against a tenant based on age, race, religion, disability, source of income, immigration status, primary language, or other protected categories. It's illegal for a landlord to harass or retaliate against a tenant for missed rent. So some examples of retaliation could include a landlord repeatedly telling a tenant that they have to move out, even without the landlord taking the proper legal steps to evict a tenant. Threats, locking a tenant out, cutting off the utilities, throwing a tenant's personal property onto the curb, other actions that are meant to intimidate or deceive. These can be considered, or would be considered, retaliatory, and there are civil penalties that could be imposed that have been increased during COVID-19. And I will say that there are some civil penalties in the Central for Disease Control order, the CDC order, that are much higher. So it's just best not to retaliate against your tenants. Okay, the rent relief programs. I'm going to only go over this briefly. Nobody in the state has details other than what we have here, because counties and cities have to make a decision by Friday about certain options they're choosing. So the program is supposed to begin accepting applications by March 15th. The rent relief funds will be available to households with incomes of less than 80% of the area median income, with priority, meaning like the first people who will get rent relief are households with less than 50% area of median income, and households with unemployed members for at least 90 days before they apply for the assistance. I looked up the area median income numbers for Stanislaus County. For a household of 4, 50% of AMI is $34,950 a year. So if you make that or less, you're in that first priority. And 80% of AMI for a family of 4 is $55,900. The rent relief funds are prioritized to pay rental arrearages. So the back rent, the rent that accrued between March or April of last year and is it January or March of this year? I can't remember. March of this year. So now, if landlords want to receive 80% of a qualifying tenant's unpaid rent from April to March of April of last year, March 31st to this year, they can receive 80% of that back rent if they forgive the remaining unpaid rent for the covered period. So they would be forgiving essentially 20% of the debt in exchange for receiving payment of 80%. There are provisions also in the rent relief packages that landlords can apply on behalf of tenants, but tenants will have to consent and participate in the process. But we know we do get landlords in other jurisdictions, particularly where they don't, they want their tenant to apply for the rent relief, and for whatever reason the tenant hasn't. This way a landlord can do that themselves, but the tenant is going to have to consent. And then the landlord, if the tenant qualifies and the landlord agrees to forgive that 20%, the landlord will get the direct payment of 80% of your arrearages. If a landlord chooses not to doesn't agree to receiving forgiving that much, a qualifying tenant can still apply and get relief equal to 25% of the unpaid rent for the covered period. And I may have this wrong, but I believe that may have to go directly to the tenant and not the landlord, but that could be wrong. Also, so that's just to handle the back rent. If they're subject to availability, funds will also be available for future or prospective rent to cover 25% of that for April, May, and June. And that part of that reason is so that tenants are insured the eviction protections because they'll be able to meet that 25% requirement before the end of June. There's also provisions in the law to have funds for utility cost arrearages. They're trying to cover the other debts that may have not been covered by prior rental assistance. So if they're subject to availability, back utility payments would also be eligible to be paid through these funds. I'm not going to go to that part yet. So hopefully your county will be letting the public know in the coming weeks how they will be able to apply for these rent relief funds. It could be a system that's statewide. I'm not certain of the details, but you should be looking to your county government for guidance on that in the next few weeks. I see we have are there questions in the chat? Or, well, did any of the other panelists read these questions?
At this point, there is none open other than David's question about for reporting in the landlord, and I asked for more details so we can answer that more clearly.
Yeah.
He has not responded back.
And again, just any reported, is there any consequence? So I think, there's penalties, there's possible civil action, depending on the type of retaliation. Oh, there's a Q&A.
Actually, David responded and you covered it.
Okay, that's great. Are tenants, excuse me. I think maybe Aurora or Mark, can you answer, are tenants receiving subsidized rent eligible for rent relief?
Yes, they are. If they have a change in their income or household status, they should be contacting their case manager as soon as possible, and Housing Authority will work to correct that issue. As far as Ms. Freitas, I can't share that department at this point in time. I know, but I can't share that. So you can always call our number as it gets updated and I learn something. I'll put it on our voicemail or prompt before you get to our extension directory. But it'll be news. And once it also, I'll post it off the Project Sentinel Facebook page, my personal page, and then also usually I'll post and renders the Stanislaus Facebook page. When we know something, I'll be sharing it right away.
Okay, does anybody, should we open it up to see if anyone has any questions about this? So the next, or maybe we'll do a poll now so we can let Charlene know. Is anybody here like a smaller landlord who's interested to learn a little bit about the possible mortgage forbearance? Oh, thanks for launching the poll. So small landlord is basically you own 4 or fewer properties with 4 or fewer units each. No, there's, oh, it looks like there's 3. Okay. We have at least 3 people who are interested in that. So what time is it? Well, Charlene, are you ready to talk?
Yes.
Okay, so we'll go over, I'll change the slide, and then if anybody has any other questions that they think of, please type them in the Q&A and we'll get to that. Okay.
Okay. Hi. I want to talk about the options that small landlords have. Obviously, it can be a significant hardship if you're not receiving the rent, particularly if you have a mortgage. As Emily mentioned, the definition of a small landlord is that you own 4 or fewer properties with no more than 4 rental units. So anything from a single family residence up to a 4-plex and having up to 4 of those units qualifies you under the definition of small landlord. You don't have to own or occupy the property. So in other words, if you're all the units are rented out, that still qualifies you for certain types of relief. And at least one tenant in your unit needs to have been impacted by COVID-19. So if you have a 4-plex, for example, 3 of them are paying rent, but one has been impacted and is not, that still makes you eligible for any relief options. Next slide. Now, the relief options right now are mostly what we'll call what is a COVID forbearance. And a forbearance means that you have a temporary suspension of your mortgage payment so that right now you're not having to pay the rent payment, the mortgage payment. It is not going to report late while you're in forbearance, so it should not impact your credit score. It should also not be accruing any late fees during this period of forbearance. If you have not applied for a forbearance, you should immediately contact your mortgage company. Most of them have a very short, brief questionnaire on their websites. So most of that can be done through their websites, or you can call their forbearance department or their hardship department. You can, once you get the forbearance, while you're not making the payments, the forbearance can be for a period of anywhere between 3 months and 12 months. Most mortgage companies are doing these in 3-month increments, renewable every 3 months if you're still experiencing the hardship. Now, once the forbearance ends, or once your situation ends, where you no longer are having the hardship, when all your tenants are paying rent again, then you can get out of the forbearance, and there are different options of what you do with this amount that's owing. The most favorable to you would obviously be a deferment. And what a deferment is going to mean is that they're going to defer these past due payments over these months to the end of the loan. at the end of the loan, whether you have 20 years left, 25 years left, 10 years left, then that will become due as a lump sum payment at the end of the loan. You can go into a repayment plan for a period maybe up to 12 months, maybe even longer, which would take the past due, and it's going to break that past due into, let's say it was a 12-month forbearance, into 12 months, which you just add on to your regular monthly mortgage payment. If neither of those options work, or if, say, the deferred option works, but let's say you're not receiving the same amount of rent you did previous to COVID, and you're now experiencing a long-term hardship due to this, you can request, in addition to the deferral, a mortgage modification. If you have a non-federally backed mortgage, you can request that modification, and the types of things that they might do would be possibly extend the term of your loan, perhaps address lowering your interest rate. These are some of the things that you could expect in a non-federally backed mortgage. In a federally backed mortgage, such as a Fannie Mae, Freddie Mac, FHA loan, you have other options. Sometimes, for example, Fannie Mae has what they call the Fannie Mae Streamlined Flex Modification, which typically roughly reduces your mortgage payment by about 20%. So there's different types of things that you can do once this period expires. So basically, the easiest way to go about this is to contact your mortgage servicer, go online, see what they offer. If you're not comfortable working with them directly, or you have difficulty getting through to them, or you feel that they're not handling things correctly, we do provide housing counseling free of any charge, so that we can work with you and your lender to try to come to a reasonable and affordable workout option for you. Are there any questions?
Okay, well, there's no questions in the Q&A. There's nothing in the chat. So apparently the panelists have done a great job. Anybody have any last minute questions as we're coming up on a little before 7 o'clock? We can get your questions answered. Those of you that requested a copy of the slides, those will go out in a little while or tomorrow morning. And once this is uploaded, I'll be posting that there as well, the whole program. Emily, Aurora, Charlene, any last words?
So we spoke a few times about the Housing is Key website. So here is what it looks like. And as you'll see down here, they have tenant protection guidelines, forms, resources. There is a lot of good information on this website. I think in the next slide, there's also, if you go to publications, there's a tenant landlord guide that's very useful for basic rental housing issues. And it was updated. And I believe they incorporated all the comments that people like us gave them. So this is, I would recommend checking this site regularly. This may be the place that, depending on your county, where you go to apply. We don't, or it will give you information about the rent relief funds. And also up here where it says select language, you can do the drop down for languages. But I believe there are flyers and other information in Spanish and Chinese and possibly other languages. And I'm just here kind of consolidated all our information. Is that the incorrect address, Aurora, or you said you moved recently?
Oh no, that's our current one.
Oh,
Yes,
cool.
on 15th Street now. It actually was almost a year ago, but we've never been open to the public.
Well, a year ago was the same.
Really? Wow.
Right, because of the whole pandemic. Yes, we moved just after lockdown started. So yes, we're just a few blocks from where we were. And I just wanted to mention, because I think there might have been a little confusion in the chat. Our CRLA flyer is not online. anywhere right now. But that can be hopefully sent out with the slides. I just sent a copy to Emily and Mark. So if you put your email address in for the slides, the flyers can be sent out to you.
Yeah, and we'll give you a PDF of the slides, and hopefully all the links will work, so you can just click on the links to.
There's one more question for Ms. Freitas. Is there any continued advocacy or mutual aid that those of us who are housed can offer at this time to support efforts to keep renters and small landlords in their homes?
I would personally say the more education and word of mouth that we can get out there for people to understand their rights is really helpful, and people going out in the community and hearing it from those that they trust is invaluable. We want people to be able to feel comfortable applying for assistance and feel comfortable seeking help if they need it and trusting the systems that are in place. But I'm not from the community, so I'll let those who are from the Stanislaus community speak.
Okay, I think we have flyer requests, which I can take care of, and copies of the slides, which I'll take care of that. Are there any more questions out there before we sign off? Are you going to do a survey, Christina?
So the survey will be sent once the webinar ends. You'll receive a link to complete the survey, and we will also send out the survey with the flyers and slides in case you would like to get to it at a different point. But we would definitely appreciate the feedback. You could fill out the survey. That would be wonderful.
It's a quick survey. You can put as much or as little as you like. So I'm just going to attack this one from an anonymous tenant. Is it Project Sentinel's stance that landlords should benefit from the 80% relief program? I will say that we generally support dispute resolution efforts where both parties are gaining and where both parties are benefiting. We don't know people's particular situation, but I would imagine that landlords, you're going to be in a better position if you receive 80% of the arrearage than if you want to wait and try to collect the arrearage from the tenant who clearly has financial problems, because going to court is step one of when you are trying to get money from somebody that you fully feel that you're lawfully owed. Even if you get a judgment, collecting on that judgment can be very difficult and not necessarily difficult, but time consuming and cost funds. It doesn't just automatically go in your pocket. So it's a question of whether a landlord wants to get a pretty good chunk of the debt in their hand right away or roll the dice and they don't know how much they'll get. But if a tenant hasn't been able to pay rent, that's a pretty good indication that it's going to be hard to collect any future.
And my part I don't ever encourage either party to do anything. I give them their options of what the possible pains could be. Mm-hmm. You might be able to go to court and get a judgment against your tenant, but if they owe 4 or 5 months and it's $4,000 or $5,000, just because you got a judgment doesn't mean you can collect it immediately. It's going to take time and work. So you might balance that against whether accepting 80% of the in arrears rent is a better deal for you. But each landlord has to make their own decision with their own business model. We got a bunch of questions in the thing. Let's see. Slide and copies will be going to everybody who asked for them. And I think that's it, unless there's more. Panelists, have anything? I think I already asked my last thing, or we are done for the evening. We can always do it again. Nothing. Okay. Well, thank all for those who attended. Again, you can always get a hold of me at Stanislaus County Mediation Center, 209-236-1577. I'll have to be sending out slides tomorrow along with the flyers for CRLA, and we'll go from there. All right.
Thank you all.
Thank you.